All right. A very good afternoon to all of you. My name is Ashish Bhardwaj. I'm the Dean of Jindal School of Banking and Finance at OP Jindal Global University. I welcome you back to this wonderful session. At the outset, let me say that it's, of course, a very difficult and incredibly challenging time for everyone. But our hearts do go out to all those who've not been able to come out of this crisis. And we do hope for a speedy recovery for those who are currently battling the COVID-19 pandemic. Given the current circumstances, we are streaming this conference, this session live on our Facebook page. So if you're still trying to figure out where to watch, where to log in, please look for Jindal Global University's page on YouTube. With that, let me extend a very warm welcome to all the distinguished speakers of this session on the theme, an economic analysis of industrial innovation and intellectual property law. I'm very happy to welcome the moderator of this session, my good friend and colleague, Professor Vishwas Devaiah. He's a professor and vice dean of Jindal Global Law School, and he also serves as director of Center for Postgraduate Legal Studies. Vishwas has been a managing director of the Jindal Global Law Review, and he's widely published in areas of patent law, innovation, health law, and biotechnology law. I also welcome all the other speakers who've taken the time out to attend this session and share their views. Mr. Subhomoy Bhattacharjee, consulting editor, the Business Standard and adjunct faculty at Jindal School of Journalism and Communication. Dr. Mohan Dewan, who's principal, RK Dewan and Company. Mr. Ujjwal Kumar, policy analyst, CUTS International. We are hosting this conference jointly with CUTS. Professor Yogesh Pai, who's with National Law University, Delhi. Professor V. Ranganathan, former RBI chair professor at IIM Bangalore. And what a delight to host all of you for this session. Vishwas, the stage is yours.
Thank you, Ashish. Thank you for that introduction. And as most of you would know, that the session is largely looking at an economic analysis of industrial innovation and IP laws. It's almost a cliche to say now that IPR was one of the primary engines that drove the industrial revolution in the late 18th century. 18th and 19th century. And IP has since then been one of the prominent areas where governments of various countries, initially in the West, and more so later on in the latter part of the 20th century in a number of developing countries, it has garnered a lot of attention in terms of what can we do to kind of facilitate innovation. And it seemed like for a lot of countries, the recipe was to kind of have a favorable IP regime. But having said that, IP has also kind of produced that kind of tension where there are points of conflict, more specifically with respect to questions of monopoly being exercised by IP holders or right owners, vis-a-vis access, be it in the form of knowledge, be it in the form of medicines. Now everyone can relate to the situation as far as the COVID situation is concerned. So there's an entire debate. I'm not saying that's exactly an IP issue, but there's an entire debate related to IP and access to medicine. So there is a larger, private ownership of innovators vis-a-vis conflict in terms of access to materials that have been created by them. Now, if you're looking at the Indian IP regime itself, to give you a context, India kind of inherited its IP regime largely from the British. Our colonial masters had IP regimes in the form of copyright law, patent law, trademark law, even before we got our independence. When India inherited its patent laws, there was an inherent tension in terms of, it was not more specifically to do with the patent law itself. It's rather the concern in terms of how companies use the patent laws in terms of, we had a thriving pharmaceutical industry, but that pharmaceutical industry was not necessarily run by Indian national companies. They were largely run by foreign companies who were situated abroad. They did have their business in India, but largely kind of chose to manufacture outside of India. And as a result of it, because of non-working of the patents in India, it did raise concern in terms of pricing, import duties, etc. At some point in time, we had a gentleman from United States, a senator, who came to India, who visited India, and kind of actually Kiefer, Senator Kiefer kind of visited India and kind of made the statement that for a developing country, India's pharmaceutical prices were really high, comparatively higher even to a lot of developed Western countries, which pretty much kind of triggered the Iyengar committee kind of coming into play at a later point in time. Iyengar committee, of course, took a fair bit of time to actually come out with a report. And as part of some of the observations made in the Iyengar committee report, the Indian government at that point in time in the 1970 decided to amend the patent law, largely to kind of encourage Indian generic pharmaceutical companies, what you could possibly call as the first phase of Atmanirbhar, right? So in essence, of course, we had our generic pharmaceutical companies, largely kind of innovating as far as processes are concerned, but largely kind of lagging behind when it came to product-related innovation, given the fact that the patent law pretty much kind of discouraged or did not kind of protect product patent regime for pharmaceuticals and chemical fertilizers. Now, the 70s and the 80s kind of threw up a scenario where you had, where the Americans called the Indian generics as the paper tigers. They called it the paper tigers primarily for a good reason, because these were pharmaceutical companies that were largely kind of, reverse engineering product patented stuff in pharmaceuticals, and were able to not only kind of meet the domestic needs in India, but also to kind of, compete with multinational pharmaceutical companies in Asia and other parts of the world as such. And of course, you had, by the late 1980s and early 90s, you had the WTO round of talks, the GATT round of talks happening. And as a result of it, the TRIPS was actually kind of slipped in. TRIPS is nothing but a set of agreements related to intellectual property rights, which was brought in as an annex to the WTO round of talks. If you didn't kind of want to be part of the if you didn't agree to the TRIPS, you couldn't be part of the WTO regime. And as a result, intellectual property rights as part of the trade regime was largely kind of inserted through the TRIPS regime, and any country which was part of the WTO had to accept it. But of course, India might come as a surprise to a lot of people abroad, played a much more important role in carving out the flexibilities related to intellectual property rights when the TRIPS regime was actually being negotiated. India flexed its muscle along with a lot of developing countries like Brazil, Argentina, South Africa, to kind of bring in certain flexibilities within the TRIPS norms. And when the WTO regime kind of unfolded and TRIPS had to be kind of implemented, India and a number of other developing countries wanted to exercise a lot of these flexibilities. And it's at that point in time, or at that juncture, more specifically Brazil, where it intended to kind of exercise some of these flexibilities when it came to pharmaceuticals. There was a large scale kind of, bashing of developing countries, which they were even blamed that you're taking the easy way out in terms of actually exercising the compulsory licensing route. And of course, a lot of African countries, a lot of them which were part of the third, the yet to develop kind of economies, were forced into a situation where they had to kind of agree to TRIPS plus norms, right? regardless of all these flexibilities within the TRIPS norms, India as a developing economy has so far exercised its compulsory licensing option only once. We've been very careful in terms, and also wise in terms of where we use those compulsory licensing provisions, right? But it's not enough to kind of say that we've played a stellar role internationally in terms of setting up a TRIPS regime itself, negotiating these flexibilities. But what have we done internally? I mean, like I said, the 1970s brought in the Atmanirbhar regime in the form of our pharmaceuticals becoming self-sufficient, pharmaceutical companies becoming self-sufficient, but we've not invested enough in terms of innovation. And if you look at the figures, our R&D, investments in R&D is pretty low. It's something to the point of 0.7 as far as the 2016 data points out, whereas developed countries like US, Japan, etc., have anywhere between 2.8 to 3.6 as part of their GDP that is being invested in research and development. And that seems to be one of the major problems plaguing the Indian industrial development. There's lack of innovation, there's lack of investment in research and development, and that seems to be one of the primary problems that seems to have actually kind of created major problems for India in terms of having an impetus for its industrial economy to actually grow. Now, apart from this element, India was also kind of challenged because of the entry of number of multinational companies coming into India, bringing their products. There's been a major, raise in the number of IP litigations. There's in the past, I mean, I can stand corrected. Dr. Mohan Dewan is here. He can point to me. I'm compared to the 1980s, the number of IP litigations in today's time is much more, right? We've had a huge increase in the number of IP litigations, and therein comes the legislative framework, the judiciary, the enforcement aspect of IP, and that seems to be an area of concern, not in terms of whether at all we can actually get a decision from the court, but the problem lies in the fact in terms of how many years does it take for these decisions to come into play. And one area where we ourselves have been invested is in the area of standard essential patents, where we've actually figured that empirically speaking, a lot of SEP related decisions to even get an injunction takes about 4.5 years. An average of 4.5 years, right? So this is an area of concern in terms of we do have the legislative instruments that can protect intellectual property rights. We do have a judiciary that is, especially the higher judiciary is fairly well versed in terms of IP, and IP related laws have actually been laid out by the Indian judiciary as such. But there are certain concerns in terms of the duration it takes. The enforcement aspect of it has been a matter of concern. And as a result of it, we've also seen in recent years, especially in 2015, when the Parliament enacted the Commercial Courts Act and recognized intellectual property to be one of those subjects that should be part of the commercial courts, we don't seem to have seen any action on that front. And it's a matter of concern for all of us who talk about intellectual property right and the role of IP, especially in shaping economies as such. So this particular session is going to focus on some of these inherent tensions and concerns related to IP and IP regimes in India. So let me first begin with the first question to all the panelists. And that question is a fairly, it's not something that is, if you're an IP specialist, not something that you haven't heard. It's a question that often crops up. How can we achieve a balance whereby innovation and wider access to such innovation are at the optimal level? Any of the speakers?
I'm Ranganathan. Can I
Please
start?
Go ahead, sir. Please go ahead, sir.
First of all, I'd like to see the place of innovation in the context of invention. You see, earlier we had the two words invention and discovery. Discovery is something which is already there, you discover, and invention is something new you have discovered. Now, I would say that innovation is a small subset of invention. Now, innovation comes very, spontaneously, and it occurs to individuals, and also it brings in large benefits, which may not be obvious immediately, but over a period of time it does. Whereas innovations ride on inventions, and they try to get smaller things, and most importantly, they are processed by corporates, profit-seeking corporates. So, as it were, these corporates are the gatekeepers for this benefit, taking the benefit, and the large benefit that the invention gives is extracted by the innovations. You see, it is as if the innovation is having a large externality and it is being extracted by them. And therefore, there is a question as to how much should the corporates get? What is the proportion of their effort and what's the proportion of their reward? Okay, so I think I would stop at this point.
I'd like to make some comments on this.
Please go ahead, Dr. Dewan.
Vishwas.
Yeah, please go ahead.
I think innovation is a very misunderstood term. The whole concept is the I's that start. Everything starts with an idea. The first aspect is the idea. When you write down the idea onto a technical idea, if it is a technical idea, when you write it down, then that could possibly become an invention. Now, invention is something that is created generally, what Mr. Ranganathan rightly said, can come into the mind. It is the universal intelligence that sends this idea into the mind of an inventor. Now that inventor he may be a part of a corporate, he may be an academician. In fact, 90% of the inventions that we file are for single individuals, and a lot of innovation is very small term. There is the organization called Honeybee in Ahmedabad that is working on grassroots innovation. Now, innovation is the next level of invention. When an invention is actually worked, there are a lot of inventions that are not worked. Those still remain paper inventions. You may file patents, you may get patents. Even among patents which are filed, those patents it's not every invention that is worked. But an invention that is worked is what we call innovation. That is what in our textbooks or in our technical terms, an invention that is tried, experimented upon. Now there is one missing I between the invention and the innovation. Profit is not a dirty word, sir. Profit is not an abuse. If a corporate makes profit, it is because there is some level of investment. I have been able to merge a lot of academic inventions, a lot of inventions of single individuals with the help of certain investments. We have started incubator centers in various institutions, like for example, in Agarkar Research Institute in Pune, at IIT Gandhinagar, we have worked with inventions and various aspects. What is needed between an invention and an innovation is another I called investment. Mostly many inventors, there are some inventors who are lucky who have the funds, but mostly inventors don't have the wherewithal and the finance to convert an invention into an innovation. And that is where a certain level of, it may not necessarily be corporates. There may be angel funding in most of what we call startups and SMEs. We have funding, venture angel funders, venture funders, different types. Some corporate funding, some level of corporate funding. These are the people that come in for converting an invention into an innovation. Of course, you only spoke of an innovation, but then ideas can lead to various other intellectual property, such as copyrights, literary works, musical works. Those are all they're not necessarily technical ideas. Designs, for example, another form of intellectual property. Trademarks is a fourth form of intellectual property. But what is needed is the investment. And when we speak of investment, that is an area. Sometimes we forget that you need that investment to come from somewhere. And at that point of time, there must be some sort of what the word you used, Vishwas, was balance. You use the word balance, and that balance becomes an important part of the whole game of, I would say, invention to innovation story. Of course, there is another thing after that, that is called integration. That is the last I that is involved in that. There must be a market for that innovation. There are some people who innovate. Many academics that come to us innovate for the sake of for academic purposes. But there must be a market, and these are the innovations that are picked up because I must integrate it into my business. The corporate or a funder or the person who starts his own business, there must be a market for that particular innovation. So that is what I wanted to say. If there are any other questions, I'd be glad to answer.
Can I request Mr. Subhomoy to kind of... You're muted. Yeah.
First of all, thanks a lot, Vishwas and Ashish, for having called me here. And I must say that it's much more enjoyable to listen and pick up tips rather than to speak, especially among a nice, good set of people who really know the subject. My point is that, I can understand where IPR issues are now coming in, but in this middle of the pandemic, as Vishwas pointed out. But I would say that there's a bad time to frame the questions. See, because the relaxations that will be needed now on IPR would not heed much on the technical need of it. It will more be an area issue of a global commons, which will therefore ask for a political solution. So what will happen now in terms of relaxation on IPR, I don't think will be decided by the legality of these issues in terms of the pharma sector. Also, while we are talking about the pharma sector, one of the first things that I would like to say is that the pharma sector has very strongly impressed our thoughts on the IPR sector issues in India. The pharma sector has been a one-off story. There is no other sector, when I've researched it, to find a similar causality on IPR that is affecting it. So to predicate our pharma sector And as I said, the decisions on IPR issues on the pharma sector in the current round will be a political solution, not a legal-based solution. I mean, not because India is presenting a stronger case. India has been presenting a case, but what pharma sector shouldn't be looked at as the prism through which the IPR issues should be evidenced. What I think has been a problem has been that we have left the institution building on IPR away, or rather discarded it in the wrong hypothesis over the decades that we can't afford it. And it is actually something which will hurt, I agree with Mr. Dewan, that will hurt the development. There'll be more profits, somebody will be cornering the profit. As a result, the intellectual ferment or the intellectual understanding of IPR has always been they versus us. And this has been a big challenge for us, for innovators, as Mr. Ranganathan was pointing out, or inventions going on from there, to be able to understand the strength which a robust IPR regime does to innovators. We have not understood how to exactly get around the problem. Let me give an example. The National Research and Development Corporation was set up in 1953 to exactly do this work. The government said, I don't want IPR. I don't want this to get into this meddlesome problem of IPR. I will instead create my own path. And we created this organization. This organization today has a total turnover of just 112 crore. That is it is just written and converted on 60 patents. That's all in the last 1 year. I mean, it is the national organization which was supposed to be shepherding, spearheading their patent regimes in India. Why is it, if we look at its annual report over years, why is it that this organization has failed so blissfully? And the reason for that is that we sort of looked on IPR as an area which we don't want to enter. So the institution building, which could have helped us, has actually not been pursued, and that is what we are now suffering from. That today, most companies which want to look at technology first look abroad, see if there's a possibility of getting it from there at a cheaper cost, and only then, if they can't get it, they try to sort of work out an Indian version of it. The fact that the Serum Institute is producing a huge vaccine is nothing to do with its IPR. It is simply a back-breaking, rigorous, hard job of producing the vaccine. In fact, it's rather Biotech which can actually somewhat claim that it has done some amount of work with the National Institute of Virology. But other than that, what has been the patenting work that has happened even during this pandemic among all the institutions that we have had? It has been, I mean, like we have had embarrassing situations. There are IITs have said, we shall be stitching out PPEs. I mean, come along. Does it take an IIT in technology to be able to create a PPE or face mask? But that is what they brought into the ministries to say that this is what we are creating. This is so ridiculous because it again harks back to the same question that we have not developed the institutional structure, we have let it go. So today, I talk of relaxing it is actually would take us back to the wrong position. Just one point, I think if I look at the startup universe, I'm getting a bit optimistic because the startups in India have been granted not too many patents, about 513 patents in the last 5 years. And in the economic survey of this year shows that startups have filed 1,000 patent applications. So I know that many startups show patent applications to show that, they have got, it eases their funding to show that they've got a patent under the belt. But I think that is where, if our startup universe expands, we shall see a much more happy development and flowering of our IPR network. Over to you, Vishwas.
Ujjwal, you have something to say about it?
Yes, before coming to the original question of yours of balancing, and since the round has gone to clarification on certain terms, I'll also like to share my thought on what is meant by R&D. There you taking the same, and you rightly pointed out that the investment in R&D is low in India. When I think about R&D, I think about R and I think about D. And when we discuss, and particularly in policy matters, I think we need to separate it. R has a slightly different dynamics and D has a different dynamics. In R, I see that there are largely two steps involved. First is Eureka, very simple. When you have that idea phase that Dewan sir has said, which can come out any time, and this R phase is largely driven by a scientific pursuit of a person or within with a scientific temper, and then an idea comes, then he or she would like to test that idea in a laboratory setup. That is also part of R, the second phase of R. So when in the laboratory setup, the idea seems successful, then the question of patent comes, patent application comes, that should be patented or not patented. And after it is patented, then one is looking for how can this invention be developed or innovation packaged together for public good or for the goods that the products that public can use for industrial production. So the patent comes after R largely and before D, and the very use of patent here is that D is investment intensive, generally speaking, and so the investor would like to have some sort of exclusivity or some sort of guarantee that he would get it in return. So R is largely a kind of a university setup or the academic setup, and D is largely a private sector setup where investment comes and then patent is used as an instrument for technology transfer, I would say, from R holder to the D partner of it. And in medicine sector, I understand that the more than 70% of invention happens in the university setup, in the public sector setup, not in the private sector setup, public funded. So why India is not having that, I think is not because of patent or patent law, but because we don't have that R ecosystem here. Perhaps we have, in last few years, we have reached to in some sectors at least to that stage or reaching toward that stage. But largely speaking, in universities, the scientific pursuit person, the person with scientific temper, do not really get that kind of laboratories or kind of guidance from a professor or kind of encouragement. And that is why the individuals from India goes to NASA or goes to USA and because there is an ecosystem there. So this is the kind of theoretical aspect that I think upon, and I think that if we are discussing from the policy or the legal perspective, we should separate R and D together because both have different dynamics and so. And coming to the balance, I think both innovation and access are important, particularly in certain sectors like medicines or agriculture, seeds. And that's why you have more flexibilities in terms of health and agriculture. The balance would lie when we have a clear-cut objective in our patent law or in our PBR law or plant variety protection law. unfortunately, Indian patent law or perhaps many other patent law do not have an object clause. And we believe that we are made to believe that patents are granted to recoup investment. Basically, I understand that originally the raison d'etre was that patents were granted in lieu of you disclosing your invention to the public so that the science prosper and more innovation or more invention happens based on those science. So when in the objective it is inbuilt that you have to have invention and you have to have in certain sector like medicine and agriculture, you have to have access also. And in my opinion, the key lies to balance, and in Buddha's teaching the middle path. Don't have that much strict, I mean, of course, strict patent laws. What is strict is again debatable, but strong patent laws and weak patent laws. So somewhere I think there should be balance of competition and exclusivity, because competition also drives invention. Unless there is a threat of competition in the market, innovation may not happen. Monopoly situation, innovation may not happen. So there should be a balance of exclusivity and competition in the policy thought process, not in the more than legal. It should be the policy thought process and the objective of the law or the application of the law. And here I would like to stop. I think we should have other questions.
Thank you, Ujjwal.
Vishwas, I couldn't hear you.
Yogesh, can we have your opinion on this?
Oh, sure. Thank you. Thank you for inviting me to this exciting panel. Well, the way in which you framed the question, I thought there was some dichotomy between, you thought there is a dichotomy between intellectual property and public interest, and obviously you raised the question from the point of view of access. But let me tell you, I think the way in which we have conceptualized intellectual property as a private interest is itself a very way to understand intellectual property. Yeah. Because without intellectual property as a form of, consider it as a regulatory instrument, forget about all the natural rights and all the other kinds of naturalistic theories about why IP is necessary. Even if you think of IP as a regulatory instrument, that regulation is necessary because firms, when they compete in prices and output, can only reach to a certain extent, wherein after that there is a kind of saturation in the market. And to break that saturation, you need a form of interventionist regulation, there are property rights, so that each one is able to differentiate in the market. And then because of product differentiation, etc., you then have another cycle of dynamic innovation. So you have one layer of innovation that is in static prices and what we call outputs, and another layer of what you call competition in innovation and product differentiation. And those cycles of dynamic competition is essentially in public interest, because if you don't have what you call an instrument like intellectual property to enhance that kind of dynamic competition, then you don't have any kind of what you call market as such. So let's take it from the other perspective in terms of access, and let's see. Let me take an example. Most recently, Bharat Biotech's success in terms of getting an indigenous vaccine, and luckily we got all the data right. Hopefully, when it is peer reviewed, the vaccine really proves effective. Because it was released as an emergency authorization. Not that I'm an anti-vaxxer, but having looked into what Bharat Biotech did with NIV, ICMR NIV, NIV provided an early stage support. Bharat Biotech did the D part, as Ujjwal has rightly mentioned. Now, the question today is, who is owning all the IP? Because everybody is now hell-bent upon Bharat Biotech trying to, they are asking Bharat Biotech to declare its IP in public domain. Now, what is the kind of IP that Bharat Biotech actually has? The IP that Bharat Biotech actually has in terms of undisclosed know-how and information in relation to how to actually manufacture the vaccine. Now, Bharat Biotech, for all that it is trying to do, is not able to raise up production capacities. And the government, now Department of Biotechnology, has nudged Bharat Biotech to license it to other players, at least in the form of contract manufacturing. So Panacea Biotech is the only company in India right now to produce it. Hafkind Institute, they asked and they said it will take them 1 year to start production of these Covaxin, made by Bharat Biotech. Now, what is the whole argument then? Oh, you as a state, you as a private entity that received early stage lab support from the state, you are supposed to give up on your trade secrets and other kinds of intellectual property that you may have. And I to my knowledge, Bharat has not filed any kind of patents, otherwise it would have been in the newspapers everywhere. So my understanding is Bharat Biotech only has this kind of clinical data, and the undisclosed information and know-how in relation to how to make the vaccine. Now, what has happened because of this? Because of this, Bharat Biotech has now been under pressure to, sort of reduce prices. That is another level. Now, what I'm thinking of is, what is the public interest here? The public interest could have been actually to allow Bharat Biotech to charge in private sales and for the governments to take upfront purchases at the lowest cost possible, which the government of India is actually perfectly doing by asking Bharat Biotech to give it the vaccine for 150 rupees. Now, if that be the case, then this whole price discrimination model that intellectual property actually effectively allows a player to do in the market is actually helps public interest because there are different levels of income. And if there are different levels of income who can pay differently, and if there are people who really need vaccines for free, then the government can definitely take it at the lowest cost possible. So I think this kind of cross-subsidization model should perfectly work. And instead of that, we are trying to push Bharat Biotech to open it up. But now the question is, even if it opens up its intellectual property, who is going to produce it? Because there are no BSL-3 compliant producers in India, and in many parts of the world, they are already overstretched. So I think sometimes when you ask these economic questions about intellectual property, they seem to be dichotomous, and I think that's absolutely not necessary in any context if you examine it from a very good economic perspective.
Thanks, Yogesh, for that perspective. So, taking off from that particular first question, one thing that comes to mind is, of course, we always have we had this question about 6 years ago when the UPA 2 was coming to an end. The bigger criticism was policy paralysis, right? So one major question that we all need to ask is, if the innovation is not happening at the level at which it needs to happen, if R&D is not happening at the level at which we aspire it to, for a country that aspires to be a developed country, challenging major economies like China and United States, we need to kind of ramp up our R&D, we need to kind of increase innovation. So the bigger question is, what in terms of policy, or is there a problem in terms of policy, or is there a regulatory concern that we need to address in order to kind of, enable innovation to happen at a faster rate? So question to all the panelists. Maybe Mr. Ranganathan, Professor Ranganathan would want to kind of take a stab at it first.
Thank you. First of all, as one of the panelists had said, or rather had wondered, how come IITs have come up with face masks and PPEs? I want to endorse his idea that we just don't have a R&D ecology in our academia. In other words, to put it bluntly, we are a bunch of second-raters. That is partly an issue of status of the academicians, as well as the status of the monetary position. That's why if you look at IIT and look at and even IIM, both these institutions, they are known for their students who have a lot of global mobility, and they are not known for their teachers. So here we have to think and ponder this issue. Now, going from the Indian to even global level, even if I look at US, while the number of doctorates, etc., are overrepresented for India and China, but the number of people who get Nobel Prize is far fewer. Now, I can only explain this or hypothesize this by the Maslow's hierarchy of needs, where the Indians are satisfied with the basic needs and social needs. They don't go aspire for the self-actualization needs, which requires, research, concentration on research, etc. So I would say that it requires a lot more thinking of fundamentally changing the level playing field for the academicians. The Atmanirbhar has to come in terms of supporting intellectuals. Right now, ministry does not have a queue of who is good, who is not good. Okay, so doing it through the ministry would be a disaster. We are doing things like, taking one engineering college and converting it into a IIT, changing the name. Somebody, the Nigel Lawson in UK said, but just by putting stripes on a donkey, you don't make it into a zebra. So that's what we are trying to do. So the question which you had raised in terms of how do we encourage R&D is a lot of things have to be done. One more thing, even foreigners are able to exploit the Indians better. Through KPOs, we have knowledge process outsourcing in India. Now, why is it our own IT companies are not able to pick the best? The best of them go to the KPOs of GE and so on. So then, not only give them money, but also the job challenge. Neither of it is available in our Indian corporates. So first of all, they don't spend enough on R&D, as you had brought out in terms of statistics. And that is because they are very happy with the low-hanging fruits that they have. So they don't have incentive to move up the value chain. And that requires not just a craving for money, but for a craving for self-actualization, corporate self-actualization, if you will. That is something which you have to go into the domains of psychology, why Indians are not like that. I'll rest here.
Thank you, Professor Ranganathan. Over to Dr. Mohan Dewan.
Vishwas, I think I'm going to have to take an absolutely diametrically opposite view of what Professor Ranganathan is saying. And I would also retort to Dr. Bhattacharjee. I have the benefit of firsthand because I worked with, I am the attorney for NRDC. So I file patents for NRDC. I also file patents for the Serum Institute because I happen to be in Pune and probably I'm considered as one of the good patent attorneys in Pune. So I work with Serum Institute, I work with the National Institute of Virology, and I work with the with various academics. Sorry, that was just a background, and I did not want to, but I just wanted to say that I've got, I know the kind of research that is being done in academics. There is some seminal work, there is some excellent R&D work that is being done by IITs and the various universities. I believe we have, if these were channelized properly, we can have, I mean, there are just a few figures that I wanted to share. In 1992, the number of patent applications filed in China were 0. They started at 0 level. Today, they are the leaders in the world with 300,000 patent applications, which you are probably aware, Vishwas said that they are the largest number of patent application filers in the world. They reached that stage. We are still around the 50,000. We are talking about IP in patents, whatever, medicinal and pharmaceuticals IP. We are still around the 50, 60,000 mark. Every year it's between 50,000 and 60,000 number of patent applications, where the world is, we are speaking about a huge number of patent applications worldwide. But that does not mean that we do not have R&D. We have an excellent R&D. But the issue is not that what the R&D is, the whole purpose of the R&D that is here. Every person aspires, the R&D people, the technical people aspire that their first haven is that I need to go, I want to do good R&D, I want to do my doctorate, or I want to do my MSc, and I want to go then go to the United States and work. Today, or United States, Europe, wherever, I want to do my post-graduation there, I want to file, join a corporate, I want to do that. For example, we have an organization in Pune, an excellent computer technology, it's called PICT. Pune Institute of Computer Technology. There is 100%, every student in PICT every year virtually goes off to the United States. When it comes to patents, we did a statistical survey. There is, out of the number of inventors, 1/3 of the inventors on patent applications in the United States is an Indian. There are a large number of, even in pharma, whether it's pharma, biotech, whatever, there are large number of the inventors are Indians. The problem is not because why do we not file patent applications? Because we do not have an inventor and R&D, in spite of whatever we train, whatever. I largely work for the domestic companies. I largely work for domestic inventors. And they do not have faith in the patent system in India. Because the fundamental thing is that the Indian patent law says that your patent is not, even after going through the entire rigorous process of patenting, and the section says that your patent is not prima facie valid. Now, why would somebody go through the entire torture of getting a patent granted when at the end of the day that patent is not considered valid? And that is the tragedy. Now, as far as courts are concerned, of course, there is the whole system of courts in India are not patent, excepting, for example, maybe the Delhi High Court and the Mumbai High Court, and to some extent Chennai, and to some extent Calcutta. The courts are not patent friendly. They don't understand. They have not done patents. It is impossible for them. For many laws, even judges, IP, intellectual property, forget patents, but intellectual property is an optional subject. So they haven't gone through the IP regime, so they don't understand patents. So they take it off their board. Even when a patent case comes, they take it off the board. We have 50,000 patents. What are we? I mean, the whole issue is unless there is you believe in a system. Unless you believe in something, unless you have faith in the system, you are not going to It's not a matter of R&D and patents. It's a matter of belief in the IP system itself. We believe in the trademark system. Therefore, we are one of the largest filers of trademarks in the country. We believe in the copyright system. Therefore, there is a very active copyright registrations that happen in the country. But we do not believe in the design system, and we do not believe in the patent system. R&D is extremely strong. I believe every year we are missing out on about 500,000 good patents, good R&Ds. I'm speaking of the good R&Ds having worked with, just because of a faulty educational system that is there. The educational system teaches the scientist to only list his publications. In the US, nobody bothers about how many publications that you have to your credit. They believe in how many patents you have to your credit. In India, it is the Lord Macaulay system that somebody mentioned. We inherited that as part of the thing. But the whole issue was that the emphasis is on publication, and everybody knows. Dr. Mashalkar stated that once you publish, you perish. Once you patent, publish, and prosper. These were the words, and unfortunately, many good patent applications are lost in India. A lot of R&D is not protected, cannot be commercialized, because nobody will want to commercialize an R&D which is not secure, at least for that 20 years. Everybody speaks about monopoly, and when you come to the question of pharma, I will talk about. I'll talk about that particular aspect. There are some excellent pharma, but the life patenting is the lifeblood of the pharma industry. Without patents, we would be anywhere in the world. We will still be relying on aspirin. Nobody would have gone beyond aspirin and maybe the first penicillins. Nobody would have filed. Nobody would have developed. There is no incentive to pharma unless there is a patent regime. There is a reason for that, which I believe I'd like the others. I'd like to hear some of the others talking. As Dr. Bhattacharjee said, it is important to hear people say. Go ahead, sir.
Over to Subhomoy. You're muted.
You know, when Dr. Dewan said that he would sort of look at a different perspective, I was wondering, but I'm so happy to see that he's essentially saying what we talked about, Vishwas, and what I think Yogesh also said. It is the patent culture, and that culture, the institutions had been thrown away for decades. This is looking very serious. So let's take something on a light-hearted note. Hindi films or Bengali films that I know of, I think it happens to others. Look at the number of music that had been over the years plagiarized without any compunctions, that does not tell us about a healthy system of respect for copyright, for intellectual property rights. I mean, I fully agree with Dr. Dewan. The trademarks we protect. 5,000 patents that have been filed by the startups. Only about 1,600 have gone on to the next stage, which is the request for applications. You know that only when that is done, then the patents are excellent. So it just shows that the companies are yet to realize that there is a need to work on their patents. And I think the problem again comes from the fact that institutions like Jindal, will be doing a wonderful job if we say that we support the institutionalization of the system. For something that can happen for a quick, useful today, we are throwing out the baby with the bathwater. Let us encourage the business of taking patents. It is what we need. It is what, I fully agree with all the panelists. I think all the panelists are saying that the people aren't taking out patents, and because it is not rewarded, it is not considered a useful idea. people have to be pushed. And one of that push, the government can't work on patents, but government must have the companies which actually sort of try to work out via media of saying, I can't work or my technology is good, but only if I can get an exception from the can do it. We may have a problem today, tomorrow we'll have a climate crisis, we have a water crisis coming up, there are several other crises. And each time we shall be asking for exceptions to or safeguards. If our people, as Ujjwal was saying, must be demonstrated on the battlefield. If those technologies are really useful, let's put the money on it and let's see, and only then it'll work. Otherwise, we'll come back to this, ab initio first principles. That's my point. Thank you. Over. Vishwas, your mic.
Ujjwal, over to you.
Thank you. I think the original question was the regulatory changes or the things that we want in India so that innovations happen more. I'm not able to pinpoint that, but could give some of the blocks where we can have those changes or retain some of the regulations, I would say also. First, I think we should start with the school. And I agree with Dr. Dewan that our system in India is not very experimental as such. The education in India is not very experimental. It's more of a mugging or a ratification of type, and lost many books, but hardly any experiments based education system. So if at all there any regulation is required to change that education system right from schooling, to make the kids more inquisitive, to make to inculcate more of scientific temper into the kids, I think then tomorrow we have chance of becoming a good innovative country where we have lots of innovations. Then coming to and this whole also applies to the whole R ecosystem I was taking about. We have a good development ecosystem in India. What we lack, I think, is the research phase of ecosystem in India. Secondly, in terms of, say, for example, in patent laws, we have a very strict patent criteria, patentability criteria than many countries, where we don't recognize, we don't give much of a wide patents, so that wide patents are generally restrictive to further research and development in those sections. So I think that should be retained, not only retained, but we should implement that more vigorously. I understand that our provisions like Section 3D may be under pressure when we are having closer relationship with the United States. What we import from United States is the ecosystem, the research ecosystem in India. Without, and we should export the kind of stricter patentability criteria to United States. They need it also. In some sense, they need also, their economy is also very concentrated, and it's very fluent. And they also need to tighten their moods on the quality of patents. Just the number of patents may not matter much, but the quality of patent also matters. Then we also come to various kind of regulations in form of, say, in Invention you have drug approval regulation or similar kind of other marketing approval regulations. In biotech or in biologics, I think our regulation or generally the model that has developed, I understand that, I'm not a scientist in that, but I feel, I understand that it is perhaps more restrictive than to achieve the objective of safety, efficacy, and of the drugs. I'm saying that because at present I understand that the regulation requires the biosimilar producers to reach out to the innovators or the original drug makers for every vial approval, so that their bioequivalence are to be proved very regularly, not unlike the chemical medicines. So that regulation may be looked into in that sense, so that there is an ecosystem of more D in India, and that more D may translate into more and more into the R part, as when we, so that there is a kind of demand from industry for people from universities or colleges, such kind of people is required, and so some research mind can kind of translate that from G part in India to the slowly and slowly towards the R part. So these are my understanding on this.
Over to Yogesh.
Thanks, Vishwas. So, from what I understand from all the discussion, the question was more towards what do we see is lacking in the innovation ecosystem, at least from an economic analysis of law. That seems to have been the thread. So, I think there is a serious confusion among various instruments, amongst various pillars of the state, be it the executive, the judiciary, and the parliament, in terms of the normative objectives of the laws, particularly laws that deal with, that have to deal with the economics of IP. The first one being the IP system itself, the patent system itself, for example, patents and trade secrets. And I understand, Vishwas, you have a separate question on what the Supreme Court has done on these aspects. I'll leave it aside. But if the normative goals of the patent system or the trade secret system has to be to protect the patent holders, increasingly you will see, not just in India, but in many other jurisdictions also, that it is becoming more and more of a leaky right, just like copyrights, because you have a system of remedies that could allow you to move from the property rules to the liability rules, where the court is going to intervene and decide the amount of compensation by refusing an injunction. It has not happened so much, with respect to certain kinds of patents, but in relation to pharma particularly, you can see that has also happened in India, wherein the courts have directly moved on to deny an injunction and to, award damages. So the normative objectives of the patent law are in serious question. The second problem is when you have patents and you want to transact, because the patent allows you the power to, also alienate your property through either assignment, particularly licensing, you would see that the normative objectives of contract law in relation to protecting expectation interests arising from the property rights are also not settled. So you will see a string of decisions of the Supreme Court, not in relation to intellectual property, but in relation to contract law, wherein there is serious ambiguity, with reference to what are the normative objectives of contract. Move on to then a situation where, say there is an abuse of intellectual property, then the normative objectives of competition law have to be at least settled for some time. That, competition means not, harm to a single player, but harm to competition as such, industry-wide competition. And competition law should not attack or should not seek competitive outcomes, but must seek competitive process or preservation of the competitive process. Are these goals clear in competition law? That's a very important question. And then fourth, if competition law is not helpful because competition law is ex post, except in case of mergers and acquisitions, you have laws that are designed for market failure or regulatory laws. And it's a situation where the objectives of regulation also with respect to how you would impose outer limits on patent law or trade secret law or copyright law particularly, and we'll come to a Supreme Court case in the next round, then I think there is a complete mess in terms of what the normative objectives of all these laws are. Because all these laws work in tandem with the intellectual property rights system and help in having a kind of innovation and R&D ecosystem. Otherwise, I think it's simply a kind of ambiguous terrain for anyone who wants to be in the Indian economy and to make any sense of what it in terms of innovation, and it will just remain a market or at best manufacturing.
Thank you, Yogesh, for pointing that out. And one important question that people who work on IP and innovation, especially in the Indian scenario, tend to ask this question often. How efficient are our courts, more specifically in kind of delivering justice, especially when it comes to IP-related matters? And we've had a whole host of problems and, of course, a whole host of reforms that have come into play, wherein probably the powers vested in certain appellate boards have been taken and transferred to the high courts so that they might actually get to step in and decide on IP-related matters. So my question is, what do we really need to do in terms of IP adjudication, more specifically at the higher, at the High Court and the Supreme Court level? And you've always seen that when you read judgments from courts in US and UK, more specifically in UK, in US, that there is a whole range of economic analysis that comes into play when they're analyzing an IP dispute, right? We haven't seen that level of sophistication as yet in our adjudication as such, but it doesn't necessarily mean that our courts are not adept to kind of handle such issues. But what reforms do you suggest or think in terms of how our courts need to kind of handle some of these cases? And how have our courts done in terms of economic analysis of IP cases? Any of the panelists?
Should I start?
Yeah, please go ahead. Please go ahead, Dr. Dewan.
Vishwas, I would humbly disagree with you on one front.
Wonderful.
The judgments that have been written, for example, let us say, the IPAB judgments that came out from Manmohan Singh, from Prabha Dewan, who was one of the earlier chairwoman, I would say. I mean, and Manmohan Singh, both when he was in the Delhi High Court and when he was, the judgments have been I would say, comparable to any good judgment in the United States or for that matter in the UK. Of course, the style was Indian. The style was not the US style, which is very different. The US style tends to be more verbose, the judgment style. But all your economic conditions, the reasons why the judgment was granted, what is the purpose of the patent, why it was granted. And I would, if anybody is interested, I'll share some gems of judgments of Dr. Manmohan Singh when he was in the chairman of the IPAB and of the Delhi High Court. Delhi High Court has been giving some beautiful judgments. The Bombay High Court, some of the judgments of Justice Kantawala, excellent judgments on an excellent analysis as far as these judgments are concerned. I would say that the judgments that have come out from the high courts, particularly the Delhi High Court, which has now become a center par excellence for IP litigation in India, has the judgments are second to no other judgments in India. In I would say in the world, if you're comparing to the two US and European judgments. Quality of judgments, quality of language, quality of insights into what the patent stands for. That is one. But now the government, as you know, recently took a very, very retrograde step of abolishing the IPAB. And the whole purpose of the IPAB was that because the courts were burdened, because the courts were not specialist courts, because they did not have where evidence was to be documented where it was needed. In the IPAB process itself was very litigant friendly. Now we are going to go back to the regime where we are going to have this is going to go into the Commerce Court. Now there are 5,000 now these cases that have been there at the IPAB will have to now go back to some high court. It may go to Bhubaneswar, it may go to Uttarakhand court, it may go to Simla, it may go to Kerala, it may go to I think you are from Karnataka, so it may go to the Karnataka High Court as far as that is concerned, or it may go to any court depending upon the litigant. Now they are able to document 5 cases. The IPAB registry is able to document 5 cases. There are 5,000 cases that are pending into the IPAB. We are talking about 1,000 days for just transferring of the cases from the IPAB to the courts. That itself is going to be a horrendous task. There is no explanation. The court, they did not consult anybody, either the lawyers or even the IPAB team itself was there, or any jurists, that we are suddenly disbanding these tribunals, the intellectual property appellate tribunal. We are doing that. Now, having said that, the reform that has to be there is the kind of reforms that are there, for example, in China, that is there in Germany, that's there in Europe. We need to have specialist IP courts. Only then will we have a regime. Only then will we have and specialist trained. I had the privilege and the opportunity to give some lectures to some of the judges at Bhopal. At Bhopal, you have the National Judicial Academy, where I was asked to come and train to give talks to the judges it was very little. I was even privileged to be able to give that kind of little insights to the judges that we were able to that they could. But there is more needs to be done. We need to have special IP tribunals and IP patent courts which are there, which will take these forward and not burden the normal commercial courts and litigants. Basically, we are not talking about the burden to the courts. Now in the courts, we will have to go in the regular evidence. There will have to be examination, and there will have to be cross-examination, and now that's going to burden the entire IP community, which was the tribunals were doing excellent service. That is my comment, and it is unexplicable what this, and I can only say that there is total lack of understanding of what is needed as far as their requirement to disband this particular tribunal. It was not a matter of finance. It was not a matter of therefore I can only use the word inexplicable. We are all dumbfounded, but that why these tribunals were disbanded.
Okay.
I'd like to hear my friends. Yes, sir.
Thank you, Dr. Dewan. Anyone else? Ujjwal, I know that Yogesh would want to speak. Okay, Professor Ranganathan, please.
Yes, sir.
Sir, you're muted.
Sorry. I want to take this opportunity to raise one of my concerns, in the sense how both regulators and judges, they can do very well with a dose of economics, particularly industrial organization. You see, and I'm going to illustrate this through a series of caselets. First was I was an academic activist, as it were. This GMR Energy, which was called Tanir Bavi Power Company. They had a power purchase contract with Karnataka Power Transmission Corporation. And this was, they had inherited a competitively bid project. And so in the power purchase agreement, they said the fixed charge will be 4 cents for the time being, but it will, however, be exactly what it is at the time of financial close. That means after the financial close, they will actually get the details. But everything was over and they found the total cost was 2.05. And then still they said 4 cents they want. And it went up to all the, tribunals, etc. So the tribunal, reconciliating body said, yeah, that's even though it is subject to a ceiling of 4 cents, ceiling was there, but then the arbitration tribunal said this was got by a competitive bid, and in the competitive bid 4 cents was there, and therefore it's okay. They have to give 4 cents. And it came to the regulator again, and this time the regulator took the extraordinary step of convening a second hearing, public hearing. There we went and gave hammer and tongs all the reasons why it should be only 2.02 and 600 crores were involved. So the regulator said that we are not going to make you recover this, because even the government had said pay them, So regulator said, I am not going to authorize you to recover it from consumers. Your duty as a licensee is to the consumer, etc. Now, the thing is here, this was a case when there was we were transitioning from a fixed price, cost-based power purchase agreement to a competitively bid price. So what is the change in market structure and what comes to be a primacy, etc. The judge has to understand it clearly, and the lawyer for the company, Andhya Rujina, argued beautifully. It was a nice argument. If you are buying an apple, would you ask its price, or would you say, what is the cost of producing that apple? So he said that. So when will you ask the price, and when will you ask for the components of cost, and what is written in the power purchase agreement? There has to be some clarity. Now, there was another case where the Central Electricity Regulatory Commission said, okay, higher cost. Tatas and Adanis had incurred higher cost because Indonesia, they had said, whatever be the price of you are charging, international price will apply for tax purposes. So the cost was more. So they said, power purchase agreement is non-est. We don't want to do that. You as a regulator fix the price. So the regulator went along, the regulatory tribunal, dispute tribunal went along, but the Supreme Court, at the level of Supreme Court said, contract enforcement, this is what you have agreed for the contract. I like that judgment, but there was a revision petition and they reversed that judgment. So what is the basis of such reversal? Is it based on economics or political power? So on the, on the whole, I can give a number of such instances. One more instance was PNGRB versus the city gas distributor. Now, the PNGRB gave a order, this is your cost, so this shall be your price. The company went into argument saying that you don't have power to fix the price, because in Electricity Act, there is a power, explicitly a regulator will fix the price. But here in PNGRB Act, it talks, preamble talks a lot about introducing competition, but doesn't talk about price, because they said you have HPCL, IOC, etc., and market will play itself and so on. What is okay for petrol is not okay for gas, because gas is a monopoly, and the PNGRB has given. So the lawyer said, where is the, look at the act, this is not there, and therefore the lawyer won. I was in an embarrassing position, because as an academic, my support was with the PNGRB. I was also the director of the board. The board had, the company had won. So I said, this High Court judge must have realized that the act very clearly says to foster competition. For competition means to fix prices, etc. So that is the point, that with a greater amount of economics, informed decisions may be taken.
Thank you, Professor Ranganathan. Yogesh and Ujjwal, we have about 2 minutes, so kindly wrap up with your response.
So, Ujjwal, you want to go first? Thank you. So, I just wanted to bring one case to the notice, just to show, how the Supreme Court, for example, decides on the question of economics of intellectual property. This is Star India versus DIPP. Decided in 2018. And this relates to challenging of certain TRAI regulations that had to deal with the question of pricing by these broadcasting organizations in terms of having a bouquet price vis-a-vis having an individual price. So if you want to buy individual channels, the price would be highly priced, and if you buy a bouquet, the price would be lower. Supreme Court unfortunately did not understand price discrimination. So at the end of the day, what did the Supreme Court say? Supreme Court said, because the contention that was taken by Star was that, look, copyright law provides us the rights to, deal with the content, and TRAI should not deal with the content. And if they were trying to impose restrictions on our ability to price discriminate, because, they wanted a kind of flat price for bouquet and also a flat price for individual channel, not moving beyond ₹19, then, it doesn't make any economic sense. The Supreme Court said, well, it may not make any economic sense, but the question is, TRAI's law and TRAI's regulations are in public interest and copyright is in private interest. This was the absolute simplistic analysis that the Supreme Court engaged in on the question of whether intellectual property and using copyright, for example, for the question of consumer price discrimination or price differentiation should be, allowed to be thwarted by a regulation through TRAI or not. So does that mean now that in all intellectual property laws, we are going to have a kind of overriding provision saying, this law will prevail over all other laws? Is that the reason why, the Supreme Court is saying that, they don't understand price discrimination? So this is just one example that I wanted to bring out finally towards the end of the session. So I think the problem is also, as Mr. Dewan rightly pointed out, that it seems just inexplicable how Indians and Indian government engages with the intellectual property or other laws. Removing suddenly the IPAB without even a discussion paper and a green paper or a white paper, whatever you want to call, I think was a retrograde step. If you wanted to really say that there were certain problems with these tribunals, You should have brought in a paper, had a short discussion and done something about it. I think the way forward may be to increase the strength in the high courts and have specific benches within the commercial courts, to deal with IP related cases. I don't see any other way, to kind of deal with routine appeals that will arise from the patent office, to deal with such kinds of issues. Thank you.
Over to Ujjwal.
Let me be brief. I don't have much exposure of court cases and such, but I understand that there are certain issues which are very unique to India, and say for example the BT Cotton case. There you have two IP laws involved in it, and we have a sui generis case, and then you have a patent. So what law would apply to a BT Cotton seed? Was the crux of the dispute, in fact, and it is still unsettled as such. So we also need to think that, and would that court rely or should rely on more of the amicus curiae or the academic inputs on this, so that their understanding is much better in that sense, because these are unique. You may not find any precedent anywhere in the world that two IP laws are applied in a case where a court is discussing about. And then second, also I think more jurisprudence or more clarity is needed on. Time and again we have seen that there are case or injunction cases filed against Commission of India about its jurisdiction, while in some of the past cases, Delhi High Court and all have clearly kind of stated what constitutes the jurisdiction of CCI and where patent authority comes in, and particularly in the Ericsson case and all. So I should just stop here. I think the time is up. Thank you.
Thank you, Ujjwal. Thank you all the panelists for your insights and views. It's a fairly complex scenario where we are at right now when it comes to COVID and COVID-related vaccinations. So because of paucity of time, I've had to kind of hold myself back with respect to questions related to questions of compulsory license and access to COVID vaccines, etc. But that raises a whole range of other complex kind of conversations as such. So thank you once again, and it was an enriching discussion on aspects related to R&D, innovation, and of course the role that courts can actually play with respect to IP and IP-related innovation as such. Okay, thanks a lot.